Hello everyone, welcome to our webinar, Your Legal Compass, Navigating Regulatory Terrain, our second webinar in the new Professional Services series. My name is Sean Rooney, I'm the Victorian and Tasmanian Membership Manager and I'll be your host today. Before we begin, on behalf of Austmine and our presenting companies, I would like to acknowledge that I am hosting this webinar from the lands of the Wurundjeri people, so in the language of the Wurundjeri people, Wominjaka, which means welcome to you all. We acknowledge the traditional custodians of the various lands on which we all meet today and recognise the Aboriginal and Torres Strait Islander people attending this webinar. I'd also like to pay my respects to their elders past and present and extend that to all leaders of all cultures and backgrounds in our multicultural nation. The webinar series is designed to connect our members and stakeholders with leading professionals who can provide valuable insights across various business disciplines. Today, we continue the series with Your Legal Compass, Navigating Regulatory Terrain, focusing on knowledge and strategies in protecting your intellectual property, or IP, to safeguard your innovations and managing legal risk related to workplace accidents in the MET sector. We will then conclude the series with Your Growth Path, exploring the role of training and development enhancing organisational capabilities. The format of today's webinar consists of a short presentation by each of our member presenters, followed by a Q&A session. If you have any questions for any of the presenters throughout the webinar, please type them into the Q&A box at the bottom of your screen. If your question is directed to a specific presenter, please note their name in your questions. This webinar has been recorded and will be available for on-demand viewing later on. So without further ado, joining us today are two representatives of two leading member companies who will share their strategies for protecting your intellectual property and managing legal compliance. Today's presenters are Fito Pando Molina from Harris Gomez Group, and Fito is the Australian practice lead of the Harris Gomez Group. Fito has 26 years experience as a lawyer, is admitted to practice law in Australia, England and Argentina. His main expertise is in corporate, commercial banking and finance, IP and technology, and is experienced in the full range of IP, legal and commercial matters relating to METs, including IP litigation. Our other esteemed speaker is Greg Smith from Jackson McDonald. Greg is an international award-winning author and qualified lawyer who has spent more than 3 decades specialising in safety and health management. Greg works with clients, helping them to understand their responsibility for safety and health and develop processes to discharge those responsibilities. In addition to being a lawyer, Greg has also worked as the principal safety advisor for a major oil and gas company and general manager of health and safety in a transport and mining services company. Greg holds various board positions and taught the accident prevention unit at Curtin University in Western Australia. And for those that don't know, Curtin University is one of the top courses for mining and mining engineering in the world. Greg is the author of Management Obligations for Safety and Health, Paper Safe, The Triumph of Bureaucracy in Safety Management and Proving Safety Wicked Problems, Legal Risk Management and the Tyranny of Metrics. And he's also co-author of Risky Conversations, The Law, Social Psychology and Risk, and the editor of Contractor Safety Management, which won the 2014 World Safety Organisations Education Award. That concludes the welcome and introduction. So I'll like to jump straight into our first presenter, Fito, from Australian practice lead at Harris Gomez Group. So if you take it away, please, Fito, it'd be fantastic.
Thanks for the intro, Sean, and hello everyone, and thank you for joining us today. So I'm going to move on to present the importance of protecting your intellectual property. Right, so we will start from the basics. I mean, I know that this might be pretty obvious to everyone, but it's a good place to start. So what is intellectual property? Well, basically, is the property that comes from your creation, be it trademarks, which is your distinctive brand and logo, and it basically entails your market recognition. So your identity in the market, how people recognize that it is you and your company and not somebody else. Patents, and that is about inventions and processes. industrial designs closely linked to patents, but mostly to do with aesthetics, shape, configuration, surface patterns, and that kind of aspect. Trade secrets, now these ones are not something that you can register, but is still intellectual property that you should be looking after. And copyright, which is mostly about intellectual works such as articles, books, writings, art, etc. Now, the point of protecting your intellectual property is that this is value, your intellectual property relates to a value that your business created, and therefore what you want is to turn that value into revenue, and at the same time prevent others from profiting from your creation and your intellectual property. So to do that, you need to have in place an IP protection strategy. Now, an IP protection strategy is a combination of elements which are both preventative and remedial. So basically what you want to do is to register a brand and inventions, designs, etc., and assert that ownership right contractually and also, against the world at large, and make sure that should you have to defend it, you'll be able to do so, and also to enforce your rights. So there's a lot of elements that come into play. And we're going to go through them one by one. So how can you protect it? Well, the first and most obvious step is to register your IP wherever you can, and where you cannot, then you can still protect it through other means. You need to make sure that you brand, mark, or label your IP protected property to the effect that this indicates your IP rights to the world. So this signals that they are your ownership. When it comes to registration, one further point is to remember that registration is relevant not just at the start of your trademark, or even more importantly, a patent, but as your product evolves and the patent has changes, your product, your invention changes, then you should update that registration as well. A further point as to how you can protect your intellectual property is documenting the development process of how your property came into being. So basically, this means that you should be keeping thorough records, including drafts, design, correspondence, etc., and other communications, that should you be in a litigation process to defend your property, well, you can support your claims with that, it's your evidence. Another point that's very important is the confidentiality aspect. So that has two sides to it. So one is internal, the other one is external. So internally, we are talking about having confidentiality clauses in your employment contracts, and make sure that your workforce is well aware of their obligations and the value of your IP, and to be able to spot breaches in that IP, and to be able to report them to the company to take action. Externally, when it comes to confidentiality as well, we're talking about NDAs, when you're talking to a third party, looking at entering into commercial agreements, or even, before you start discussion, you have to have that in place to ensure that even before you disclose anything about your IP, there is a recognition that this is your ownership, and confidentiality will be observed in respect of that. Contractual recognition, well, this is a pretty obvious one as well. So when you're entering into a contract, say a distribution agreement or a joint venture, or you name it, you have to have a bunch of fairly robust clauses that cover your IP adequately. And this has to do not just with the definition of what is your IP under that contract, and also an accurate description of that, but also a good description of how you're going to protect it, and where the boundaries are. Legal enforcement, this is a very important one. You have to be ready to protect your IP. So it is very important to remember that protecting your IP is a costly exercise, but it's a lot more costly if you don't protect it. So you need to make sure that all that registration, all the foregoing points are going to be brought to bear if you need to enforce your IP rights, because there is a breach. And so you need to take someone to court, for instance, or you need to defend yourself, as it were. Now, when do you need to protect your intellectual property? Well, before you use it or disclose it. As we all know, once there has been a disclosure, or once knowledge of your IP is out there and it's unregistered, then you are unprotected. And where do you need to do this? In each and every country where you will do business. And as I said before you land in that jurisdiction. Now, you need to remember one thing, and is that there is no worldwide patent or trademark. Some people believe that this is a thing. We've heard it from some clients. There is no such thing. You need to register in every country where you're going to be doing business. Now, the next point is about pitfalls, and this is probably the last takeaway I wanted to come up with a few examples. So obviously, the main one is failing to do any of the previous points that we discussed, and kind of like to reinforce the importance of the last point I mentioned before about registering intellectual property in each jurisdiction where you go. We have a client that has a patented product and has presence in a bunch of countries around the world. Luckily for our client, our client has a solid IP strategy in place, and as a result of that, this patent was registered in every country where our client has a presence and does business. And some time ago, a third-party competitor, in breach of our client's patent, made a sale of a product that basically copied our client's patent into one of these jurisdictions. And this allowed our client to sue the competitor in this foreign jurisdiction. The case is not over yet, but everything points like we have a very robust case, and it's looking very, very solid, and it's looking promising for our client. Now, if this protection had not been in place in that country for our client, if our client had failed to register their patent in this foreign country, there would have been nothing that our client could have done. And we are talking about millions of dollars in business worth. Now, another point is inadequate monitoring. So the story I just told, talks to us about monitoring, because the reason why our clients, or basically their business partner on the ground in this third jurisdiction, discovered that this deal was going on, and we were able to stop it on its tracks as the import was taking place. So monitoring is very important. If we had delayed in monitoring, then the genie would have been out of the bottle, and the products would have entered the market, and there would have been very little that we could have done in terms of taking effective steps. Inadequate and poorly worded contractual clauses. Well, this is a very big one, because there are, there's a bunch of aspects to this which cannot be overstated. So common pitfalls are, for instance, the use of subject matter experts to word technical IP clauses without legal input to have in a contract. So the result of these can be that there is an adequate technical description of the IP, but there is an inadequate legal protection of it. Conversely, lack of use of subject matter experts to draft a clause can be a pitfall as well, because you can have the opposite scenario where you have great legal protection, but it's not really covering the product as such, or only parts of it, only parts of your IP. So an example of that is, say you've got, software, and the clause refers to protecting the algorithms in the software. Well, that's not enough, because software, there's a lot more to software than just algorithms. There's code, there's the interface, there's a bunch of other things as well. And then, there is a further point, which is inadequate litigation clauses. Now, this is a very big one, because if you've got everything else in place, that's great. You've registered your property, you've got a contract that looks great, but when it comes to the litigation clause, it falls short. Now, the problem with this is very tangible and very real, because Australia has treaties or agreements with only about 20 countries to enforce awards. So basically, it means that you sue your counterparty in Australia, but your counterparty is in a third country, somewhere else, and you need to go to that country. Now, if your counterparty is not in any of these 20 countries, then you're in trouble, because you might have to relitigate. I mean, it might get to that point. And so all the trouble that you've gone to here in Australia might be for nothing. And also, you've got the fact that protections in other countries might be different. So to avoid that, what you can do is have an arbitration clause. And so an arbitration clause that is properly drafted is able to cover you in case that you're successful in your arbitration in over 170 countries. And this is, at the same time, it's a lot quicker. It's got better subject matter expertise connected with the process, and it's not public. So it's a lot more cost effective, like on a number of levels. And having said that, I thank you for your attention.
Thanks, Fito. That was a fantastic presentation on the various ins and outs of IP. And I'll remind the audience too, if you have any questions for Fito, please put them in the chat box, and we'll get to those in the end. Next, I'd like to welcome Greg Smith, the Partner of Workplace Relations and Safety from Jackson McDonald, to present Jackson McDonald view on workplace safety. So if you take it away, Greg, that'd be fantastic.
Cheers, thanks. Thanks for the invitation, and g'day everyone. I've only got 15 minutes to scoot through what is a reasonably complex topic, and this is to do with the issue of evidencing safety. And the reason why this has come up in my sort of work experience is organisations spend an extraordinary amount of time and effort collecting and collating work health and safety metrics. So that might be injury rate data, it might be the closeout of action items, it might be the number of inspections done, the percentage of training completed, volumes often of material, which then very often again makes its way into a monthly health and safety report. What is problematic at one level, or concerning perhaps at another level, is that none of this information has any real relevance in the context of legal proceedings if you're prosecuted for a breach of health and safety legislation. So in 33 years, I've never been able to pick up a client's monthly health and safety report and say, oh, this information is going to be helpful in defending the organisation from work health and safety proceedings. I think it is also strongly arguable and supported by a fair bit of academic research that the amount of all this information we gather also adds no value to our understanding of whether our workplace is safe. So it just strikes me that there's an extraordinary amount of misdirected energy going towards producing a whole lot of information that tells us nothing that we need to know. So I'll just sort of explain how we get to that point just by a couple of narrow examples. So just as a general proposition, the baseline you're looking for from a evidencing safety or proving safety, demonstrating safety, from a legal risk management perspective at least, and I think this applies to a practical safety issue, is can the organisation demonstrate that it has proper systems in place to manage the hazards in the business, and can it demonstrate that it has adequate supervision or assurance processes to know that those systems are in place and effective. Now, the history of safety prosecutions tells us that most organisations cannot answer either of those questions in the event of a workplace accident. And if you want to put that in context, this idea of proper systems and adequate supervision is really the working definition of what does it mean to do everything reasonably practicable, from a court's perspective at least. Problematically, the metrics that we try to gather, and again, I'll show you how this happens in a moment, but the metrics that we try to gather to support the legal position are not reliable. They are filled with organisational assumptions and organisational corruption. And when I say organisational corruption, I don't mean that in a pejorative sense. I simply mean that in the context of the corruption of task and process in an organisation caused by all the competing pressures. So it's one thing to say that a worker needs to do a pre-start inspection on a piece of equipment, and we're going to count the number of pre-start inspections that get done, and that becomes our metric. And so the measure of the success of pre-start inspections is the number of inspections that are done. Well, we know that more often than not, inspection checklists are simply a tick and flick process that add very little meaningful assurance to safety, because anybody who is involved in some sort of assurance checking checklist normally has a whole range of other pressures competing with them at the same time, which effectively compromises the integrity of the checking process. And when you go into most modern, particularly larger organisations, we have lots of checklists. And the more checklists we have, the more likely it is that some or all of them are going to be compromised by tick and flick. But even if that's not true, and you sit there and you say, no, Greg, our checklists are done well and they work well, even if that's correct and the information in those checklists is not tainted, it doesn't matter. The metrics they're not reliable and they don't inform the baseline. They don't tell us what we need to know. If I have a worker who has been killed or injured by a piece of machinery that malfunctions, the number of checklists in that organisation is not evidence that the risk was managed. So we need different evidence, and the current systems of safety reporting and management don't deliver that different information. If you're interested in these, my two most recent books, Paper Safe and Proving Safety, explore these themes in a lot of detail. As I say, it's a large and complex topic, but if you are interested, that's probably where you would go to find out more. But the way it works is something like this. Safety is full of good ideas. We seem to come up with new ideas every second week. And those ideas are meant to have a purpose and make a contribution. So if we're introducing a new system of safety conversations or a new regime of inspection or some new bloody safety culture program, it's meant to have a purpose. It's meant to achieve something in the context of that initiative itself. And then over and above that, which is harder to measure, I mean, we can measure whether the initiative meets its objective itself. What's a bit harder to measure is what contribution does that initiative make to safety. But then, and this is where it really becomes problematic, is that almost inevitably we introduce a process, okay? We can't just go out and talk to people in the workplace about safety. We have to slap a process on that, which says, here's the form you have to complete when you have a conversation, and here are the number of conversations you have to complete. And inevitably, what that leads to is the measurement of safety is not a measurement of safety, it's a measurement of safety activity. It's a measurement of the number of things we do. So we know how many inspections we've done, we know the percentage of training completed, we know the percentage of action items closed out, as an example. So what we don't know is we don't understand efficacy. So we don't understand whether our processes are effective. We don't understand if they achieve the purpose they're designed to achieve, and we don't understand the contribution our ideas, our initiatives are supposed to make for safety. And that becomes a sort of self-reinforcing loop. So not only do we not know if the initiative or the idea itself is not effective, we don't know if the checking process is effective because we don't monitor the checking process. What we do is we count the number of checks that have been done. So what this leads to, and some people, if you're listening to this today from a safety management perspective, you'll recognize this, is that we take a lot of those metrics and we translate them into traffic lights, red, amber, and green. And this whole process is hugely problematic for a range of reasons. So first of all, it creates an illusion of safety. So if I'm a manager and I'm looking at my monthly health and safety scorecard and the metrics are green, which more often than not they are, I might make the assumption that that means that those initiatives are leading to a safe workplace. The reality is there is no evidence for that. And all the metrics are telling the reader, even though they don't know it typically, all they're telling the reader is a lot of stuff has been done. And more importantly, the correct number of things have been done. The other problem, and this, I'll show you a case study in a moment, and this is what drives the tick and flick mentality amongst health and safety processes, is that the process becomes the purpose. So a worker typically is not completing our safety and health processes to achieve the safety and health outcome. They're going through the motions of doing the process because somebody's going to come and count or collect or check that they've done the process. And very seldom do they check whether that process has been done well or whether it makes a contribution to safety. So one of the sort of poster child of this type of bureaucratic nonsense is probably something like the Take 5. So if we say, for example, that it's a good idea for workers to think about the safety issues associated with a task before they start work, yeah, that's a good idea. It's meant to have a purpose. It's meant to help workers to identify hazards. It's meant to help them implement controls arising from those hazards. And maybe it makes a contribution to safety, although the research tends to suggest that Take 5s make no contribution to safety. But let's pretend that there's something there. It might lead to a risk literate workforce. It might lead to safer work. It might lead to less incidents. No evidence to support that, but in broad terms, it may do those things. What's problematic, though, is we slap a process on that idea. So we say workers have got to think about the issues associated with their task, but it's not enough for you to think about it. You have to fill in this piece of paper so we can collect and count those pieces of paper. And then we set a target for the number of take fives, and that target gets generated into a scorecard, and the scorecard goes into the reports. And so we can stand up and confidently say the correct number of take fives have been done. But what's problematic in that scenario is at the end of the day, all we know and all that is reported is how many take fives have been done. We assume potentially, I don't know, but conversations I've had tend to reveal this. We assume that workers are risk literate. The take five doesn't evidence that. We assume that hazards have been identified and controls are in place because of the application of the take five process. Again, that is seldom true, particularly when you look at some of the low-level nonsense that goes into take fives. And very often, the purpose becomes the process. So the only reason I, as a worker, am doing this take five is because someone's going to come and collect it, or I have to put it in a box in the admin, or it's going to be counted, or whatever the case may be. And anybody who's had any involvement with safety in mining or construction or anything like that over the years will appreciate what I'm talking about. We know that workers complete a week's worth of take fives in the crib room. We know that workers get their kids to complete take fives while they're on R&R, so that they've got, a whole shift full of take fives in their pocket when they start on day one. We know these things happen, and anybody, as I say, who's been exposed to those industries will be aware of that. Now, in broad terms, the question's not, are take fives good or bad? I mean, I think you picked up my view on that on the way through, but how do you know what's happening in your organisation? And if I can just share quickly some examples just to explain what that looks like. This is a coroner's inquest, a Queensland coroner's inquest, looking at a dual person fatality resulting from a faulty track maintenance machine doing some rail maintenance operation. And you'll see there in the second last paragraph, the observation that the crew members told the investigator that complete adherence to the checklist was time consuming. And so their usual practice was just to do a cursory checks on key items and then to mark the whole checklist as complete to indicate compliance. And the coroner observing that this was a tick and flick process which over time eroded assurance. Now, I suspect, based on my experience and matters that I deal with, that the tick and flick approach to safety paperwork is probably more prevalent, far more prevalent than we're prepared to admit. But it comes up time and time and time again in court cases because organisations simply, all organisations have is evidence that these documents are being done. They have no evidence that they are being done well, and they have no evidence that they are meeting their intended purpose or making a contribution to safety. And so, in broad terms, there has to be a question asked, I think, that if an organisation is not prepared to invest the time, energy and effort to understand if their systems are working as intended, why bother to have the system? Because there is a reasonable argument that you are probably just building a database of non-compliance if you are not actively engaged in some sort of meaningful verification process. Again, just by way of last example, I don't think I've got another one after this. This is the Farrakhan decision. This is a single person fatality during a construction operation where a worker was hit in the head with a steel I-beam during a lifting operation. But again, you see these very standard, very generic, very typical WHS processes around a pre-start toolbox meeting, a J8J, and a start card, which is another version of the Take 5. Now, again, anybody who's been involved in mining or construction type work will appreciate how mechanistic and bureaucratic these processes can be. You roll up to a pre-start meeting, nobody's got anything to say. The supervisor just drones through what they've been told to read. Everyone signs the JHA without reading it and pulls a pre-done start card from their pocket, and off we go. And you see the observation here that, you know, and this was accepted by the court, that the signings, you know, this exercise in going through the motion of signing off on all of this stuff we're supposed to have done, was nothing more than a tick and flick exercise. And yet, organisationally, the fact that these pre-starts have been attended to, these documents have been signed off, these start cards have been completed, is taken as assurance that the health and safety processes are implemented and often effective. And there's simply no valid basis in most cases for those assumptions or to form that view. The last one I'll share, again, another coroner's inquest, single person fatality unloading a truck, and this idea that we produce documents, we go through processes, we produce documents that can pass audit requirements, but this idea that the workers in the field find the documents hard to comprehend and of limited relevance to their daily activities, I think is a real issue that sits behind a lot of the problems we have in evidencing and assuring workplace health and safety. And I suspect that if we invested far more time and energy in confirming worker comprehension and relevance of process than we do counting take fives and checklists and corrective actions, we would probably drive better outcomes than I think our current processes achieve. So I'll just tick through the end. I mean, if there's questions, Sean's going to manage the question process, I think. But otherwise, thanks for the invitation. Thanks for the opportunity to come and just briefly share some ideas.
Thanks, Greg. That was fantastic. And it was I don't think most people realise, very important two presentations today. One, IP is very important for the protection of all our members' intellectual property in various markets, and safety is the number one priority of the mining industry. And from that brief webinar I've heard today, it's actually opened my eyes to a lot of different safety systems I've used over the years, and I'm thinking already of ways to improve based on meaningful sort of systems rather than tick and flicks. So with that in mind, it's now time for the audience Q&A, and if you haven't already submitted a question, please use the Q&A button at the bottom of your screen, and we'll start off with a question probably from me first of all, and this one's in relation to Greg, and it's probably the underlying theme of his whole presentation is we cannot rely on traditional metrics as evidence of safety. What should we do?
Well, the whole point of the book Proving Safety was to articulate a different approach, and my view is we need to shift organisations away from exercises in data collection to an almost permanent research project. The idea that we are continually deep diving the critical risks in the business to understand if they're operating effectively. So we need to get rid of the superficial counting of activities and shift to real ongoing critical analysis of key risk. Now, that comment often gets mistaken for some sort of critical risk program, and many of the larger mining houses have those. But those types of processes are just as likely to develop into tick and flick as well, because they're often very checklist driven, and they can often identify the artifacts of safety being in place around an incident, but they're very poor at identifying, capturing and communicating levels of understanding and risk awareness.
Thanks, Greg. That's a great answer. And I've got another question for you. So you obviously hit a nerve with a lot of people with your seminar. So this one is, if organisations adapted and found a way to ensure that processes are completed for the purposes of its intent rather than the purposes of filling out a process, would recording and monitoring the process be suitable to show that checks are done with the correct intent?
Yeah, I think it's an interesting question. So there's some interesting things happening in the market at the moment. There's a group called Risk Talk who are doing some interesting things with recorded JHAs, which I think take things a little bit further. I think recording of some of the conversations are potentially helpful as well. But what I would say is that the same risk arises once you start going down that path. So, for example, one of the sort of big safety initiatives to come out in the mid to late 90s was around in-vehicle monitoring systems and those sort of geolocation for vehicle drivers. And what they would produce is a massive database of driver behaviour data. But I don't know how many cases I've been involved in where you've got this collection of data that nobody examines or verifies or checks. And so you get, for example, a vehicle rollover on a particular point on a ROM pad. And then when you go and check the data, you found that for the last 6 months, every vehicle that's gone through that point on the ROM pad has sped. So not only is the collection of data not being utilised to understand safety risk and manage the risk, it's actually creating the legal risk for the organisation, because there is the data that the organisation ought to have known about this risk and dealt with it. So the issue is really understanding, if you're putting in place an initiative, you need to understand what is that initiative designed to do and how are we going to confirm that it's achieving the outcome, as opposed to just going through the motions of doing the thing.
Thanks a lot for that, Greg. That's great. And I've got another question here, and this one is for Fito. In your presentation, you mentioned the convenience of having an arbitration clause in contracts. And the question here is, what is the worst case scenario if we have a standard litigation clause?
Right. Yeah. So basically, the whole point of this is if you actually win your litigation or your arbitration, the real point here is enforcement, and this comes to play especially when the party that you're suing that is suing you is in another country. So the thing is that for a normal litigation clause, you will be relying on having an enforceability treaty with that third country. And where it doesn't exist, you've got problems such as whether your judgment is going to be recognized in that other country. And, many countries don't automatically recognize foreign court judgments. And this means that you might need to file a new lawsuit to have your judgment recognized. I mean, this can span from just having the judgment recognized. It might be a rubber stamping exercise if you're lucky, but if you're unlucky, you might have to relitigate the whole thing. And when the latter happens, you have a bunch of other ramifications, such as local laws come into play. And therefore, the whole legal basis that you litigated upon and won is no longer there. Now you've got a different one. And that also entails, what the outcome might be. I mean, it might be a completely different outcome, it might be the same outcome. And if you're lucky and you have the same outcome in terms that you won, then your remedies might be different. So, there's all sorts of ramifications with that, with the proposition of, well, let's not have an arbitration clause. Let's just rely on, the usual, well, we'll use, say, New South Wales law and the courts and tribunals of Australia.
Thanks for that. Now, I've got we're rapidly running out of time, and I've got 1,000 questions myself, but I'm sure we can follow up with everybody later. So there's first a question for Greg, and then one more for Fito. So Greg, stakeholders like governments, investors, community, etc., want to understand safety performance in all operations and how we can possibly demonstrate this publicly with a movement away from metrics, which, whether suitable or not, are at least understood towards something like critical risk analysis. Is that what you're sort of getting towards?
No, I think I understand the point. Yes, we've known for decades, for example, that injury rate data is not a measure of safety performance. Okay? We've known that most major accident inquiries around the world for the last 30 or 40 years have demonstrated that the organisation can show very good injury rate performance data, but their safety management systems are fundamentally flawed. The Deepwater Horizon was one of the classic events of that kind of notion, that the Transocean event, the Transocean rig in that event had gone 7 years without an LTI, but the presidential inquiry into that disaster said that the fundamentals failures of safety management in that disaster were such as to call into question the safety culture of the entire industry. That kind of criticism. I think there's an assumption that underpins the question, and again, I'm not being critical of this. There's an assumption that underpins the question that says a bad metric is better than no metric at all. I would disagree with that. I think the bad metrics that we use are positively misleading and create false senses of security, that illusion of safety. But again, I understand where it comes from. It comes from typically, very often, institutional investors like superannuation funds requiring that kind of data. And I think the challenge, this is not an operational challenge. I think this is the challenge for the health and safety industry, is to try and increase the level of safety literacy amongst institutional investors so that they're asking for different information to actually get an understanding of the safety of their investments.
This one, like, just add on to that. So this is very critical to the mining sector overall. So how can the mining sector demonstrate that it's publicly performing in a safety way if you don't use metrics? Can you suggest any way
Yep.
it can move on?
Again, the Proving Safety book sort of outlines a model. I think we move to a system of narrative reporting that describes how and what steps we take to understand, examine, and analyze our critical risks. It's a movement away from numbers without context or assurance to a system of descriptive narrative reporting that describes what is actually being done to understand the health and safety risk in the business.
Oh, fantastic. And I presume that could apply for environmental stuff as well, from my point of view. Now, last question, which is all we have time for, and that's for Fito. So, enforcing patents can be an expensive pursuit. What are some alternative options for SMEs?
That's a good question. It can be this can be read in a couple of ways. So enforcing can be taken to mean, I'm not sure how the question is formulated. So it could be taken to mean, registering a patent or suing for breach of patent. So let's start from the beginning. Well, patents are basically the big fish of the IP world, and that's for good reason. Obviously, patents are something that is new and different and will potentially be able to make your company a lot of money. So this could be basically your money maker. Because of that reason, registering a patent, and also because it's very technical, so patent attorneys are highly skilled SMEs who really understand this that kind of like side of the business, and this kind of like engineers and that kind of thing. So obviously it's retaining that sort of people is going to be expensive, and the whole process is expensive. But then if you've gone to the trouble of registering that, then it stands to reason that you should defend it, because that symbolizes the value that patent has to your business. Likewise, if it's a good invention and you believe that it gives you an edge in the market, then you should definitely go to the expense of registering that, because then you and you alone can exploit that. And if you find that someone else is doing it, then because of the same reason, it would make a lot of sense to actually sue them to stop them breaching your patent, because they are actually milking your invention and making money out of it. So it is true, it is expensive, but not protecting your patent is a lot more expensive.
Thanks so much for that. And yeah, good points for everyone who's listening in. I'm afraid that's all the questions we have time for today. If we got all the questions that I could get, but I've got hundreds myself. So, but please reach out to Austmine team, and we will put you in touch directly with the representative, with the respective presenter. So if anyone's still got questions later on, just reach out to us, especially if you're watching this, in a pre-recorded sense. The next webinar we have is part of our professional services series, is Your Growth Path, which is be held on the Tuesday, the 26th of November. And please register that with austmine.com.au. Now, the last bit of the presentation is I'd like to give a big thanks to Fito and Greg for sharing their expertise today. It's been very thought-provoking. And personally, myself, I could spend another couple of hours on this alone, asking various questions from experiences I've had over the last 30 years or so. So thanks everyone who attended today, and we look forward to welcoming you to the next Austmine webinar, and enjoy the rest of your day. Thanks very much all.